Welcome to the season 6 finale of For the Defense, and we've got a special one to finish up the season. Two great lawyers, two great friends of mine, Howard and Scott Srebnick. They've been fighting and winning cases down here in Miami since I started practicing. Howard and I were both assistant federal public defenders, both clerked for the same judge, Judge Edward Davis, who was the best. Scott and I have tried a case together in Savannah, Georgia, of all places, and we recently represented a lawyer charged with extortion in Broward County, and the state dismissed those charges on the eve of trial. And speaking of lawyers charged with extortion, the season finale today, Scott and Howard are going to talk about their famous client, Michael Avenatti, who is charged with extortion in the Southern District of New York. It's got lots of fascinating twists and turns, and I think you'll really enjoy hearing from just two terrific people, two terrific lawyers, Howard and Scott Srebnick, next on For the Defense. Thanks. Hey everybody, welcome back to For the Defense. I'm here with my good friends, Howard and Scott Srebnick. Welcome to the show, guys.
Hi, David.
So we're going to be talking about Michael Avenatti today, which is, obviously a very well-known lawyer who was charged, but you guys have been representing lawyers for a long time. Howard, let me start with you. Back to the Moran Bell days, back in the late 90s, you guys represented some lawyers. Can you tell us about that case and how you got started representing lawyers?
Sure. I had just left the federal public defender in 1995 when shortly thereafter the federal government effected search warrants on law offices here in South Florida, as well as in Washington, D.C., most famously at the office of Michael Abell. Abell had been the director of the OIA in Washington, D.C., a division of the Justice Department dealing with extradition of foreign nationals. He had been eventually charged with conspiring with his clients from the Cali cartel, accused of not only lawyering improperly, but by virtue of that, he was accused of racketeering and drug conspiracy, facing mandatory minimum sentences, all in his capacity as a lawyer. And so I joined Roy Black at that time. We represented Abell at the initial stages. Eventually, Roy wasn't able to handle the trial. Scotty then came in, and the two of us defended Michael Abell at the trial, 5 months long. Seated next to us was the legendary Albert Krieger. He and Marty Weinberg represented another lawyer, Bill Moran. Moran was one of the great criminal defense lawyers of the 70s, the 80s, the 90s here in Miami. He himself had been a state prosecutor, then eventually became a defense lawyer. So Moran, Abell, and other lawyers were accused of conspiring as house counsel on behalf of the Cali cartel. The trial went 5 months, ended in acquittals on some counts. The jury was deadlocked on others. But what was most notable about it is that the two of them were seated next to half a dozen alleged drug traffickers. And so the jury was being asked to decide the fate of the drug traffickers for having moved thousands of kilos of cocaine, and at the same time trying to evaluate whether these two lawyers, by virtue of serving as attorneys for members of the cartel, had themselves joined that conspiracy. The case ended, as I pointed out, in a hung jury on some of the counts. Scotty and I did not handle the retrial, and eventually the government convicted Moran and Abell of, I think, money laundering. Both of them were sentenced. You may recall Bill Moran fled the jurisdiction, was captured in Mexico, brought back, sentenced. The appeals were unsuccessful, but that lays the groundwork for the kinds of cases that here in South Florida were becoming all too ordinary, charging lawyers as co-conspirators with their clients.
Yeah, it's always been sort of ground zero for charging lawyers, which is bizarre. I do remember, you and I clerked for the same judge, Howard. When I was clerking for Judge Davis was the retrial of Moran and Abell, and it was in front of Judge Hoovler, of course, and Moran gave his own closing argument when I was clerking. I remember going down and watching that closing argument and thinking what an unbelievable lawyer Moran was.
I watched that oral argument too from the gallery, and I thought what was really powerful was him defending his right to be a lawyer. The jury, by the way, in that case was hung. And the government asked the judge to remove the one holdout juror. The judge did excuse that juror and replace the juror with one of the alternates. It was at that point that Bill Moran went missing. I guess he felt that the cards were being stacked against him. The jury came back with the guilty verdicts. Moran was then captured, I think, within the next year.
So, Scotty, was that the first trial that you did with your brother? Because I know you guys have tried a bunch of cases and worked together a lot, and wondering how it is to work as brothers on a case. I don't know if I could do it with my brother. I love my brother, but we might kill each other.
Well, we hate each other, so it made it a lot easier.
That was the first case we had tried together. For me, I was 32 years old at the time. And, that trial came on the heels of Falcone and Magluta, which was a 4-month trial where I was really more of an observer, handling some of the legal issues, but watching some of the great trial lawyers of our century, Roy Black, Marty Weinberg, Albert Krieger, cross-examined witnesses for 4 months in that case. And then, I segued on to the Abel Moran case, in which you again had, Krieger and Weinberg. And that was 5 months. And to spend 9 months, it was like going to law school, just watching these great, and of course, my brother, who's a phenomenal trial lawyer. So just being able to watch that at the age of 32 was a great learning experience for me. And just I marveled at how some of these lawyers were able to just think quickly on their feet. And it was really fantastic. And then, of course, Howard and I have gone on to try a number of cases together. The Eduardo Masferrer, which was the Hamilton Bank case, the Avenatti case, obviously, that we're going to talk about later. We had a trial in front of Judge Kahn together, a drug case, and a few others. So, listen, you, David, and Howard are really the two best trial lawyers in America right now. And to have tried cases with both of you during my career has been really a great privilege. And you guys play chess while, a lot of other lawyers play checkers, and it's great to watch.
Well, Scott, we're going to talk about this, but you've left the law, which is crazy to me, after you got to try all these cases with your brother. So I don't know if that's what led you to leave or what happened.
Well, actually the Avenatti case, which went to verdict in February of 2020, was my last trial and the last real substantive case that went to trial. And it happened right when COVID was really accelerating. Remember, COVID really became a thing in about February of 2020. And I was already at that point burned out after 28 years. I don't know how you guys do it, really. But the stress of these cases and the inability to sleep when you're in trial and even just leading up to trial, it was taking its toll on me. And my wife's family is in the real estate business. And of course, when COVID happened, there was Armageddon in the real estate world. And I just decided at that point, number one, I wanted to help her family out navigating through that. But at the same time, there was just a burnout factor, and it was a great time for me to make the transition. And I truthfully haven't looked back. And in fact, David, when you asked me to be on this podcast and talk about the Avenatti case, I had to go and refresh my recollection about so many details, because now that I have gone into a different world, it's actually very, very difficult to go backwards and to remember. I marvel at how Howard remembers details about the Abel and Moran case from now 27 years ago.
Just when you thought you were out, we suck you back in. You talk about the stress. You've got more hair than Howard and I put together.
I'm going a little gray, which is it's good that we're just doing this by audio.
So let's get into the Avenatti case. Maybe Howard, you could tell us who Michael Avenatti is, and then Scott, you can tell us about the cases that he was charged with. So Howard, tell us about who the man is, Michael Avenatti.
So Michael was first in his class at George Washington University Law School, a brilliant man, very skilled trial lawyer, had won some huge verdicts as a plaintiff's lawyer. And when Michael was vaulted into the spotlight through his representation of Stormy Daniels, he did make an enemy of a past and potentially future president of the United States by taking on Donald Trump through his representation of Stormy Daniels. And so Michael found himself under the watchful eye of the Department of Justice, and it landed him in federal courts, both in New York and in California. He was charged in the New York case, the one that Scotty and I handled, with extorting Nike, extorting one of the biggest apparel companies in the world through settlement negotiations on behalf of a client, and we'll talk about that in a minute. But as well, Michael was also accused of having misappropriated funds from Stormy Daniels, his client, as well as having misappropriated funds from other civil litigants who he represented, settlement proceeds that had gone into his trust account but did not make their way out to the client. And so he was facing, by the time we were representing him, 3 different indictments.
And Scott, you guys only represent him in the Nike New York case. How do you get involved in that case?
So if I recall correctly, Howard, he had reached out. Michael lives in California. Roy spends a lot of time, Roy Black, Howard's partner, spends a lot of time in California, and they had become friendly. And Michael had reached out to Roy when Michael had gotten indicted or arrested. And I think Roy had some other matters pressing that he couldn't devote his attention to the case. So he ended up referring the matter to me. So I took on the representation. Michael hired me and Jose Quignon to represent him on the Nike case alone. And then, of course, I then sucked my brother into the case to help out because, I think Howard is really somebody who I see eye to eye with and trust, and he's a great lawyer. So Michael in New York in the Nike case was charged, as Howard said, with defrauding Nike. So Michael represented a coach named Gary Franklin. Gary Franklin was the coach of a basketball team in California named the California Supreme. It's a high school team of different age groups. And at one point, the California Supreme had been sponsored by Nike, and they were playing in the Nike Elite Youth Basketball League of high school players. And of course, the premier team is the under 17 team. And at some point, Nike pressured Coach Franklin to pay players to get on the California Supreme, to recruit players by paying them. And at the time, that was a violation of NCAA rules. Now, as we know, there are ways around it, and it's actually part and parcel of that. It's encouraged. But at the time, it was considered misconduct, at least under the NCAA rules. And Nike was pressuring, 2 executives at Nike were pressuring Gary Franklin to pay players, which he did. And then there were false invoices to get reimbursement for the payment to players. And at some point, these 2 Nike executives, Carlton Dubose and Jamal James, decided that they just wanted to terminate Franklin, his sponsorship, and really bring in other coaches to coach the California Supreme. Franklin got really upset by it. Obviously, he lost his team. This was the elite team. And so he contacted an entertainment executive named Jeffrey Auerbach, who was a friend of his, whose kid had played on the Supreme, to really advise Franklin about what he should do, how he could get his team back, how he could go after Nike. And Franklin and Auerbach, Coach Franklin and Auerbach, the advisor, went back and forth for a year, sending text messages to each other, meeting with each other about how they should go after Nike. Franklin wanted justice. He wanted to go after Nike. He wanted to bring them to their knees. He wanted these executives fired. He wanted Nike investigated for corruption. And they literally spent a year sending thousands of text messages to each other about how they were going to go after Nike. And remember, right around this time, the U.S. Attorney's Office in New York had indicted some Adidas executives for paying players. And so this was a scandal that had engulfed college basketball, and Nike was already in the middle of it, dealing with subpoenas that had been issued to it. And so, Franklin wanted justice because he saw what was happening with Adidas, and he really wanted to expose what was happening at Nike. And finally, after a year of going back and forth, Auerbach, the advisor to Coach Franklin, offered to contact the number 2 guy at Nike, a guy named Slusher, to see what he could do about getting justice for Gary Franklin. And Auerbach was the guy who was touting his relationship with Phil Knight, the founder of Nike, that he could deliver for Franklin. And Auerbach contacted the executive at Nike, the number 2 guy, and Slusher basically said, I don't want to deal with you. Go talk to the lawyers at Boyce Schiller. So Auerbach got no relief for Franklin after a year of talking about it. And so this is right around the time where Michael Avenatti is achieving prominence on television, representing Stormy Daniels. They're watching him on television every night. They're texting each other about how this is the guy that they need to hire. This is the guy who can get them press. This is the guy who can bring Nike to its knees. This is Avenatti was, in their mind, the guy who could really bring attention and light the fire under Nike. And so they hire Avenatti and they have meetings with Avenatti. And, and it was because of his high profile, because of that he was a fighter, because he could generate press, because he could get attention, that they hired him. And they have several meetings with him. They outline their overall goals to Avenatti, and Avenatti runs with it. And Avenatti decides he's going to contact Mark Garagos, who's another prominent lawyer in California.
We've had him on the podcast.
So Garagos, if you recall, had represented Colin Kaepernick against Nike and had relationships with Nike. And Avenatti contacted Garagos, figured if he brought Garagos in, he could get a meeting with Nike and get this matter resolved for Gary Franklin. So ultimately, Avenatti sets up a meeting with Boyce Schiller, with the lawyers from Boyce Schiller. Garagos and Avenatti go to the meeting. And in that meeting, the Nike lawyers from Boyce Schiller start to get, I guess, the way they testified, they felt like Avenatti was trying to shake them down for money, because they testified. This first meeting was not recorded, but they testified that Avenatti essentially was saying, I'm going to go to the press and I'm going to expose this entire corruption unless you pay Gary Franklin money and you hire me and Garagos to conduct an internal investigation of Nike. And the Boyce Schiller lawyers, knowing that Nike was already in the crosshairs of the U.S. Attorney's Office, realized that this was their way out, or their way to resolve their situation with the U.S. Attorney's Office. They reached out to the U.S. Attorney's Office and told them that Avenatti was trying to extort them. And of course, Avenatti was at that point an even bigger target, right, than Nike. And so the government then wired up the Boyce Schiller lawyers for the next several meetings and phone calls with Avenatti.
So Boyce Schiller lawyers agree to get wired up and go into meetings with Michael Avenatti. I mean, imagine as a lawyer, if the government asks you to do that, it seems pretty wild to me.
It was wild to us too, but I guess they justified it, they rationalized it, because they were defending their client Nike, and they knew that this was Nike's ticket to safety, was by turning on Avenatti. And Avenatti at that point was almost the biggest fish in the country to catch.
And so, Howard, I remember reading about the case and seeing Avenatti making some pretty over-the-top statements on tape, having the client buy the balls, these kinds of things. And I know you open on that in the case and tell the jury, hey, you got to not pay attention to all the 4-letter words that Avenatti uses.
Yeah, so the initial concern was that jurors might be offended by the use of foul language, which Michael Avenatti used with great passion during settlement negotiations. But lawyers have the right to choose their words, and this is not a courtroom. This is in the offices of a law firm. And I wanted to make sure that the jurors were conditioned for the kinds of words that Michael chose to use. And I told the jury, he's brash, he's aggressive, he might even be offensive, but that doesn't make him a criminal. And so I thought it was really important to get the jury ready for all of that. And what made this case so unique is that every single conversation between Michael Avenatti and the Boies Schiller lawyers was recorded after that first initial meeting. The evidence was undisputed. The jury could hear Michael's words as they came out of his mouth on tape. And what was even more unique is that his co-counsel, Garagos, was in the room with Michael as this so-called extortion was going down. And Garagos, who I've worked with on other cases, an outstanding lawyer, had represented Michael, I think, on a traffic infraction, on some other small matters. And so from Michael Avenatti's perspective, his own lawyer, Garagos, was sitting right next to him as supposedly, the government later says, Michael Avenatti was committing extortion.
Mm-hmm.
Garagos was never charged with a crime. Garagos was in the room as Michael was making every single demand of Nike. And not once did Garagos say, gentlemen, we need to stop the meeting. This has gone too far, or Michael, you need to step out, or anything that would have suggested to Michael Avenatti that he was crossing the line. And when we tried to subpoena Garagos to testify before the jury, Garagos, who by then hired a lawyer quite wisely given the government's threats, declined to testify, as was his privilege. We told the judge that we were sure Garagos was never going to be indicted. We were sure that the government was using the threat of indictment in order to keep Garagos from taking the witness stand. So this case goes all the way to the jury without the jury ever hearing from Mark Garagos, the lawyer who was sitting in the room with Michael Avenatti during every single so-called extortion.
This always bothers me because, you know, the government, of course, can scare a witness from testifying, threaten a witness, or make the witness think he's going to get charged. The only person who can give the witness immunity is the government, so they hold the power both with the threats and with the ability to get the guy. We always say to the judge, you know, why don't you, judge, grant immunity or force the government to declare? The judge, of course, never does. And so the government is able to keep the defense from calling important witnesses. And then you can't even comment in closing about why the witness didn't testify. It just seems so unfair that the government's able to do this. Happens all the time.
It does. And there continues to be an open question that one day, hopefully, the Supreme Court will step in, because it used to be in the Third Circuit, judges could give judicial use immunity to allow a defense witness to testify. In the Ninth Circuit, there are a couple of cases. I think one is called Westerdahl, the other is called Straub, where if the government intentionally manipulates the grants of immunity, granting immunity to some but not other witnesses to make it impossible for the defendant to get a fair trial, there are decisions from the Ninth Circuit saying that that would violate due process. But to your point, the defense has very little power to compel a witness to speak. We can compel them to show up. You give the witness a subpoena, that witness has to appear in the courtroom. But that in and of itself, of course, doesn't compel the witness to speak over the assertion of a Fifth Amendment privilege. Lawyers who are faced with this question should preserve the issue and take it up on appeal. And maybe one day the Supreme Court will finally step in and say it ain't right that only the government can force a witness to testify, particularly a witness like Mark Garagos, where it was crystal clear the government was never going to indict him. And here we are in 2024, and he's never going to be indicted. I think because he didn't commit a crime. I don't think Michael Avenatti committed a crime, but apparently the Second Circuit disagreed.
David, what was particularly offensive in this case surrounding the whole Garagos situation is that the government interviewed him multiple times. This was not a situation in which the witness simply was silent as to everybody and the defense didn't have the ability to compel his testimony. The government interviewed him multiple times. They knew exactly what he was going to say. His reports had material that was clearly exculpatory of Avenatti, and we had no way to get that into evidence. The government had actually immunized him for purposes of the debriefings.
Wow, right.
But then refused to immunize him for purposes of the testimony. We argued in part that he had waived his privilege by actually sitting down for debriefings with the government. And of course, we were subject to that rule that says it has to be in the same proceeding, and an interview is not the same proceeding as the trial. And so, there was clear manipulation here. They had a chance to hear what he had to say, and then they basically threatened him not to testify.
I love Mark, and as I said, I've had him on the show before. I think he's a great lawyer. Did he agree to speak with you guys as well, or only to the government?
He did not speak to us. We can't grant Queen for a Day immunity, David. We can't grant statutory immunity, David. All we could do is invite him to talk to us. And we actually tried to move into evidence the statements that he had made to the government. That was not allowed. So we couldn't offer his out-of-court statement to the government that was solicited by the government, and we couldn't put him in court to testify. The jury never heard from Mark Aragos.
So to back away from the case for a second and just talk about things that I like to talk about when trying cases out of town, because I think trying cases out of town present really unique challenge that I know you both love to exercise. Howard, you're a big biker, and Scotty, you love it too. So, I mean, are you able to do your biking every morning, Howard, when you're in New York, or what do you guys do for exercise, and how do you stay sane when you're trying a case out of town?
Listen, I'm a warm-blooded Miami boy. The trial was in January and February
Yeah.
in New York City. There was not one chance in 100 I was going out in 30-degree weather at 6 in the morning to go for a bike ride. So I hung up the bike. I did maybe a few rounds on the Peloton, but the truth is, when I'm in trial, I have very little time to exercise. So I missed the bike, but it was an important enough case I was willing to do that. And so I think, Scotty, you may have done a few workouts, but
well, we actually walked to court, to and from court every day. It was about a mile and a half each way. So
where'd you stay? Where'd you stay?
We stayed at an apartment in Soho. But that just shows my age, David. Now I count activity in terms of steps, no longer in terms of miles. We did tried to get in 10,000 steps a day.
Right. I remember when, Scott, you and I were trying a case in Savannah, Georgia. We walked back and forth to the hotel every day and around that park. I don't know if you remember.
I remember that. Sure.
Yeah. I made the mistake when I tried a case in New York to stay right by the courthouse in Chinatown in a dump, but it was right there across the street, which made it easy. Let me ask you about picking the jury before we get into the meat of the case. I know you guys used a jury consultant in this case. Do you always use jury consultants when you can? Do you like jury consultants, pluses and minuses? Scott, we'll start with you.
It's the right jury consultant. Yes. I've had not great experiences with them, but we used Josh Dubin Research Consulting in New York, who actually they were awesome. And it's more than just selecting, which jurors, but it's the background information. It's being able to generate the social media information about the prospects beforehand and being able to review all of that they are just phenomenal at compiling. And then, of course, during the selection, they're also, very good. But in this case, it was helpful, and especially in a high profile case like Avenatti, who engenders strong feelings on both sides. You really need to know, you have to know a lot of information about it, and it helps. What was interesting, though, and it never, no longer surprises me anymore, but how little people actually follow the news. We expected in a case like Avenatti that everybody would know about the case and everybody would know who he was. And, a lot of people did, but so many people didn't. And he was on the front page of every newspaper and every television show, a headline constantly. And so, I always overestimate how well people know, the client, and often it's underwhelming.
Howard, what do you think about jury consultants?
Well, I love working with Josh Dubin and his colleague Renato because they take a big load off of my shoulders. I'm thinking about opening statement. I'm catching up on any recently delivered discovery, and to have a team like Dubin and Renato taking responsibility for jury selection, particularly when you have questionnaires and there's so much data that's being shared with us. They were fantastic. I would use them every time if they're available. And you may not know this, but Avenatti was, by the time we started trial, he was all tapped out. He did not have the funds to pay for a defense. I worked pro bono just so that I could be in that courtroom with my brother. I didn't get paid. Dubin didn't get paid. Scotty got paid peanuts. It was whatever Avenatti could afford, the little that he had after all those indictments got returned. But we thought the case was super important. It was about the law of lawyering. And I was there not just to defend Michael Avenatti, who I had only met post-indictment. I was hoping I could defend the practice of the law. I apparently was not successful. But that's why I was there. And I agree with Scotty, the power of celebrity can't be underestimated. Michael did not have the kind of celebrity you might want going into a trial. I find in other cases, particularly with athletes, when we represented the Miami Dolphins football player charged with money laundering, another case involving lawyering, Martin was charged with giving money to a lawyer as a legal fee. A lawyer you might know, David, because I believe you were partners with him at one point in time. And in that case, the fact that he was a celebrity athlete, the fact that Dan Marino was his character witness, made a huge impact on the jury. When we represented the race car driver Elio Castroneves and his sister, someone like that walks into the courtroom with a much greater presumption of innocence, not because he was a great race car driver, but actually because he was a great dancer on Dancing with the Stars. And when people like you from television, people think they know you, it gives you the kind of presumption of innocence that everybody should be entitled to. We don't always get that in our cases, and I'm quite sure Michael Avenatti did not have the presumption of innocence walking into that courtroom.
My former client, the great basketball player Dwight Howard, is on Dancing with the Stars. He danced last night and did a good job. So you're like back to your PD days, Howard, with not a lot of money to spend on trial. You have to give opening. And in reading about the opening, it looks like the judge was really weird about using exhibits, demonstratives. It sounds like he doesn't let you do that in opening.
Yeah, it was a total reversal of everything we had learned practicing here in the Southern District of Florida, and for that matter, in law school. In opening statement, I had brought to court and shown the government and the judge the demonstratives that I would like to use in opening statement. And what they consisted of were evidence that I intended to discuss in opening statement, documents that the government intended to offer.
Right.
And the judge refused to allow us during opening statement to show the jury what the evidence would show. The judge said, I couldn't predict whether he was going to allow the document into evidence. And I responded by saying, Judge, the government is seeking to introduce it. I'm not going to be objecting.
Right.
I'm pretty sure this is coming into evidence, Judge. Judge said, well, I can still overrule the government even if you're not opposing it. But the judge did allow us to use demonstratives that did not include the evidence. Judge found to be different, shall we say, than here in the Southern District of Florida, where you can always use the evidence. It's the demonstrative that tries to portray the evidence that could be objectionable. And then even more bizarre, in closing, the judge would not let us publish the jury instructions that the judge was going to give to the jury. And that really hamstrung our defense, because our entire defense was a legal defense. And I wanted to be able to show the jury, here are the elements of the offense that the judge is instructing you on. And here is the law. And here's why, following this law, you have to find Michael Avenatti not guilty. And the judge would not allow us to use the jury instructions in closing.
All right, don't get ahead of me. We're still in opening. So let me ask you about opening then. You're able to use demonstratives that don't have the evidence. So do you use a PowerPoint? Do you remember to use a PowerPoint, or how do you do it?
Well, in the old days, of course, we used the big boards, and now we just use PowerPoint. to use it on the screen.
Right.
Yeah, that's how we do it these days. It's pretty powerful. The jury can look down, but try not to distract the jury from the energy that we try to deliver through our advocacy.
Right. And, I see throughout the trial, one of the big themes of the defense is, of course, this is what Franklin, the coach, and Auerbach want Avenatti to be doing in these meetings, that they have really given Avenatti the power to be him and do his thing. And so, Scott, you and Howard both want to use the text messages between those two to cross-examine. And I just still don't understand the judge limiting you from using those texts. Can you explain, A, what you were trying to do and what the judge's ruling was?
Yeah. So for starters, the government's theory is that Avenatti committed extortion and also violated the honest services that he was supposed to provide to his client, Gary Franklin, the coach. The government said he did that in one way, which is by not only demanding $1.5 million for Franklin, but in addition to that, and that's okay, but by demanding an exorbitant amount of money for Avenatti and Garagos to conduct an internal investigation. And the government's theory is that violated Avenatti's duty of honest services to Franklin, because Franklin never wanted Avenatti to conduct an internal investigation of Nike.
Right.
And that had Franklin known that Avenatti was going to go in and demand money for himself to do this investigation, he never would have authorized it. And that was the government's theory. And the government's theory of extortion is that Avenatti had no claim of right to that money. And so to threaten to hold a press conference and to threaten to bring Nike to its knees and to wipe $10 billion off of Nike's market cap if Nike wouldn't pay Avenatti himself, that was extortion because Avenatti had no claim of right to be paid for himself. It's okay for a lawyer to go in and demand money for a client and say, I'm going to file a lawsuit on behalf of the client to recover money for the client unless you pay. And if you don't, it's going to be in the public eye and you're going to get, hammered for it, and it's going to hurt your reputation. It's okay to say that to a company, but according to the government, you can't go in and say and threaten, a corporation that they will get, hurt in the public marketplace if they don't pay you as the lawyer if you don't have a claim of right. So the whole case boiled down to whether or not Gary Franklin, the coach, had authorized Avenatti to go in and argue not only for money for Franklin, but whether it was also within the scope of the representation for Avenatti to demand money for himself.
Okay.
And our theory of defense was that Avenatti going in and demanding all that money to conduct an internal investigation was exactly what Gary Franklin wanted. He had a claim of right to that investigation, to root out corruption. For a year, as I mentioned earlier, Franklin and Auerbach were texting each other, not with Avenatti on the text chain. So Avenatti was not privy to those direct text messages, but they were texting each other about how they wanted justice, how they were going to go after Nike, how Avenatti was going to bring them to its knees, and how they really wanted to hammer Nike. When Auerbach and Franklin testified at trial, they took a 180-degree approach, and they simply said, we just wanted our team reinstated, the California Supreme. I didn't want Avenatti to have a press conference. I didn't want Avenatti to demand an internal investigation. These were all demands that Avenatti was making outside the scope of representation. So the case really boiled down to whether or not Avenatti believed it was within the scope of his representation of Franklin to demand that he conduct the internal investigation of Nike and demand a lot of money for it. And so the text messages were directly contradictory of Franklin and Auerbach's testimony at trial. They were inconsistent with it. And we wanted to show those text messages to the jury. We wanted to confront the two witnesses with those text messages. and publish the text messages to the jury.
Seems like
And the
classic impeachment, right? The witness says X, you have a text message that says Y, you want to confront the witness with Y.
Correct. That's classic. And these text messages were in their own words, and they were, diametrically opposed to the way they were testifying at trial. And the judge's ruling, his reasoning for excluding the text messages, is that those were never shown to Avenatti during the course of those text messages. And as a result, Avenatti didn't know that that was what Franklin and Auerbach wanted. And we argued that the text messages were admissible for two reasons. Number one, they were classic, inconsistent statements that should come in as substantive evidence. But secondly, that those text messages, from those text messages, the jury could infer that Franklin and Auerbach actually shared those goals with Avenatti, that they shared their desire to get justice from Nike, that they shared their desire for Avenatti to use his platform as a public figure to bring Nike to its knees. And it was fair for the jury to draw that inference from those text messages. And we argue they should be admitted in evidence for the jury to see.
Right, because otherwise the jury's left with the impression that they told Avenatti the opposite, that they told him they only wanted a settlement or whatever, when the truth is they're discussing amongst themselves exactly what they do want. So the jury is left with a misimpression if they don't get to see the text messages.
That's exactly right. And we knew the text messages were critical throughout the trial. And every night I was filing motions for reconsideration with the judge and coming up with different reasons and preserving every objection about why those text messages were critical to our defense. He didn't let them in. And then during deliberations, the jury sends out a note that actually asks for an explanation about what they can infer from the few text messages that were admitted in evidence. And so it's clear that the jury was focused on the text, on the few text messages that were offered in evidence. And even in response to the note, the judge, in our view, didn't properly respond to the jury question about how they could use the text messages, for what purpose they could use them.
Howard, one of the things I've learned from watching you in court is you don't really get flustered and upset, even when a judge is clearly ruling the wrong way and ruling against us, which happens a lot. How do you deal with this judge and with other judges when they're making a ruling that's going to hamstring you and with your defense? It's obviously wrong. You must want to pull your hair out.
Well, that's why I started my career as an appellate lawyer, because I always say the path to a successful appeal begins with a trial error. And so I figure the silver lining in every mistake the judge does is he's giving me another shot at winning an appeal. Didn't work out so well in this case. But the thing about the judge in the Avenatti case, he was equally difficult with all of the lawyers. He was difficult both in terms of his rulings, as you've heard Scotty explain. I mean, these text messages were admissible on multiple levels, not just as prior inconsistent statements, but as substantive evidence of the desires of the client, Franklin. What was his objective? In his own words. Even if he was mute, we should have been able to include the text messages so that the jury, which asked the question, can we draw inferences from the text messages that they didn't get to see?
Right.
And so the judge oftentimes lost his patience with us because he thought we were being obstinate in pursuing the interests of our client. But the judge did share some of his ire against a witness who did not understand that sustain means stop talking. The judge shared some of the ire with one of the prosecutors who happened to be his former legal intern. So I didn't take it personally. Judges from time to time are, exhausted. They're tired. They're working hard. They're working late. Scotty's hitting them with memos at 1 a.m, so I can understand why the judge might be a little restless in the morning. I try to kill him with kindness. We're all here trying to do justice. We see it in a different way. So I took it and just keep fighting for my client with with as much polite rhetoric as possible.
See, I always take it personally, so I gotta learn how to not do that. Scott, one of the big challenges in doing these memos late at night is your client is detained at the worst prison in America, probably in New York, the Jeff Epstein prison, the Ghislaine Maxwell prison, and we've read about it now, the Diddy prison.
El Chapo.
The El Chapo prison, right? Why does a lawyer charged with a white collar crime get detained? What happened there, and how do you deal with it?
So he was released on bail, but remember, as Howard mentioned at the beginning, Michael had 3 cases pending, 1 in California and 2 in the Southern District of New York. And about 2 weeks before the trial in the Nike case was set to begin, Michael was in a bar disciplinary proceeding out in California, and he was arrested for allegedly violating his pretrial release in California. And it had to do with a financial report that he had filed that the government claimed was false. And so he gets arrested and his bail gets revoked in California by the judge in California, much to the anger of the federal judge in New York, because that now, with the trial about 2 weeks away, the marshals were going to have to figure out how to get him across the country. We were unable to meet with him and talk to him for a period of time. The government is hitting us with jinx material at this point, which Avenatti, being a lawyer, was very, very much involved in reviewing. And then ultimately, the government has to detain him at the MCC New York, which, as you mentioned, was the where Jeffrey Epstein was held, and Michael, being a well-known person, was held in the SHU. So you can imagine every day after trying the case till late in the early evening, late in the afternoon, we would have to go to the MCC. We would have to get through security. We'd have to go up to the SHU area. The extra delay of dealing with that. We couldn't actually review materials on a computer initially with him. And we would have to bring stacks of documents, figure out how to sift through them, because he wanted to know everything that was going on. Then we'd get back. If we had dinner, we were lucky. And then I'd be working on motions till 1 or 2 in the morning. One of the under sort of appreciated elements of trying to defend difficulties and trying to defend cases like this is when your client is in custody. And the circumstances of his custody were particularly onerous and challenging. And so it, in our view, it made things really, really difficult to defend the case.
Although, David, I was going to just mention, the judge was very respectful of Michael's right to participate in all of the proceedings, including at sidebar, during jury selection, during evidentiary objections. Nobody thought that Michael was at risk of flight. He was being detained as a consequence of a California judge's decision to find that Michael violated bond. I think there was a real issue about whether there was any violation at all. The U.S. Marshals in New York were super professional. They made arrangements so that we could have meaningful conversations with Michael during the breaks. It's just nice to be in a jurisdiction, and in Florida, we get some of the best marshals as well, giving us access to our clients. It makes such a big difference, because to have to go to the jail every night, it was just brutal.
There are, obviously challenges with representing a detained client, but also challenges in just representing a lawyer in general. You guys have represented lots of lawyers. Most of the lawyers we represent aren't criminal lawyers. They're civil lawyers like Avenatti, but they do think they know their way around a criminal courtroom, which is, presents challenges. How was it representing a lawyer here, and just in general, is it a good experience representing lawyers, or more difficult?
It's particularly.
Go ahead, Scott. Sorry, you were on mute.
Listen, overall, it's more difficult, but obviously it depends on the person. Michael is very smart, and Michael was very involved in this case, and Michael knew the witnesses, and Michael knew what he did and what he didn't do. And so, the idea of cross-examining a witness without Michael's input was not something that we would even entertain. I mean, Michael was very, very helpful. So you have to go with a lawyer, you have to treat them with, it's not that you treat them better, but you have to really take into account their strategy, their knowledge of the case, their knowledge of the witnesses. And so you have to go the extra mile in trying to accommodate that.
Look, Michael Avenatti was a trial lawyer. I treated him as co-counsel. This guy knew more about the case than I did. I think the only person who knew more about Michael Avenatti's case was Scotty, because Scotty, launched into those text messages, the emails, all the communications. Nobody knew the case better than Scotty, and certainly nobody knew the law better than Scotty. But when it came time to know where the, shall we say, the soft spots in the government's case, Michael was our best co-counsel when it came to that, because he knew the witnesses. He'd spent a long time with them. He was in that room with the lawyers for Boy Schiller. He had looked them in the eye. I really felt that it was a huge advantage to having a client who's a lawyer who's tried cases. And so I took full advantage of it.
So David, in any of these cases, win or lose, and obviously we lost this case, but in any of these cases, you really need a team to be able to defend against the resources of the government, especially in a high-profile case where the government is throwing all of its resources. You need a team, and we were very, very fortunate, notwithstanding the result, that several lawyers. Obviously, Howard came to help out, and there's nobody I trust more than him. And then there was a lawyer in New York, Danya Perry, who has really achieved prominence in the last few years. She jumped into the case to help us out as well, and took on an important role, equal co-counsel role in the case as well. And it was, really, really valuable to have her and her team go through all of the facts, the text messages, the legal issues. She was terrific, and it made things a lot easier to deal with the challenges of trying a case up there.
And we had her associate George, who was knee deep in all of the evidence. Jose Quignon had come up from Miami. He's one of our mentors from when Scotty and I just started. And then it was the support of the Dubin consulting firm, even beyond the jury selection. I love working with a team of lawyers. David, I've been dying to get into a courtroom where you and I can actually try a case together, where you're on one side, I'm on the other side. So see if you can make that happen. All right. Maybe you have to lower your fees one day.
Yeah, I don't think I'm trying to keep up with you. So you get to the closing, and I love this. You ask the judge if you could split the closing among the brothers, and the judge agrees to let you guys split closing. How do you split it up? Like, do you split up the issues? Do you just split up the time? How does that work? Do you remember, Scotty?
Sure, Scotty, tell him.
Yeah, no, I did the opening close, and Howard, I guess I did. Is that right, Howard? I did the first one. You did the second one?
You went first.
I went first, and really I focused on the text messages that we weren't allowed to get in, but I focused on just the whole history of Coach Franklin, and arguing that everything Michael Avenatti did was in furtherance of the interests of the client. We took what little evidence we were allowed to offer in about Coach Franklin's desires, and I made and I took him through a PowerPoint, and I made the argument that what Michael Avenatti did in demanding an internal investigation was directly within the scope of his responsibility to his client, and I tried to persuade the jury that clients are not, especially in a case where the client is not a lawyer. And in this case, Gary Franklin, who was Avenatti's client, was not a lawyer. The client, under the bar rules, defers to the lawyer in terms of the tactics that can be used in achieving the client's objectives. And I tried to persuade the jury that it was in Franklin and Auerbach's best interest to let Avenatti be Avenatti. And that meant going in there guns a-blazing, demanding the investigation, and that would, in that way, it would achieve Franklin's ultimate goals of getting paid, money, restitution, and getting justice.
And Howard, I know you want to use the jury instructions as you mentioned earlier, and it's surprising to me that the judge doesn't let you do that. I mean, that's something we do in every closing, is talk about the jury instructions. Why wouldn't he let you do it, and how did you get around that?
So the judge said that only the judge can tell the jury what the law is. I'm not allowed to tell the jury what the judge says the law is. It did not make a whole lot of sense to me. I thought it was an interesting appellate issue, but the appellate lawyers did not raise it, so we'll never quite know if that rule in the Southern District holds up until someone raises it. But remember that in Avenatti's case, he's accused of trying to extort Nike by demanding that he, Avenatti, and Garagos be paid something like $12 million as part of the internal investigation. Now, Avenatti didn't just make that number up. Avenatti, during these meetings, had told Boy Schiller, let's put this in context. Michael Avenatti, a single lawyer working with a co-counsel, is accused of threatening and extorting one of the biggest companies in the world, represented by one of the biggest law firms in the world. Okay, this is not going up to your Chinese laundromat and saying, if you don't give us $500 a week, we're going to burn the building down. This is telling Nike, through their big law firm, you need to pay up because Nike has been committing fraud. Nike has been committing misconduct. And the demand for the internal investigation was exactly what the clients, Franklin, through Auerbach as well, had demanded that Michael present as part of the relief that Franklin wanted. And so I thought it was really important that the jury be able to understand that a lawyer can rely on what the lawyer believes is the client's demand and can say it in foul language, offensive language, and Michael had the right to be paid. I remember asking Boy Schiller, as part of the settlement that was being proposed by Michael Avenatti, who's going to pay the legal fees? Well, the money's going to come out of the settlement. And so Michael proposed what he thought would be the cost of an internal investigation based on Michael asking Boy Schiller, how much would you charge for an internal investigation?
Right.
And the lawyers at Boy Schiller didn't want to say they would actually charge more for an internal investigation.
Right.
And Mr. Franklin admitted when Scotty examined him that Michael was going to get paid out of the settlement proceeds. And so I couldn't understand why the judge would not let us argue to the jury the law which allows a lawyer to demand for his client a settlement that includes attorney's fees for the lawyer, all of which would have had to have been approved by the client before the deal was done. It wasn't like Michael was telling Boy Schiller, listen, give $1.5 million to my client, and then on the side, send me a check for $12 million. No, that wasn't the deal. The deal was, let's put it all in writing. Franklin will review it. Franklin has to sign off on it. Mark Garagos is part of the negotiation. It would all be open. It would all be disclosed. There was no hiding any of this. I don't still see how this could be a crime.
So was it, I mean, it sounds like a great closing you just gave. I'm ready to vote. But let me ask you, was it hard to keep your lawyer, Michael Avenatti, off the stand with all this going on? I imagine he wanted to testify.
Actually, I thought it was relatively simple. There was nothing for him to say that he didn't already say on the tapes. So the entire dialogue between Avenatti and the Boy Schiller lawyers was recorded. There was no dispute. And so I did not see an advantage to having Michael Avenatti repeat what he'd already said on tape. And of course, he was facing charges in California,
right,
and also in New York for fraud and trust account violations. So I didn't see any advantage to having Michael Avenatti testify, and he didn't disagree with us. And I got to say, look, we lost the case. Thought we should have won it. Michael thought we should have won it. Michael thought we had won it. And to this day, he has been grateful, appreciative of everything we've done. And I have a lot of love for Michael Avenatti, even if he's admitted he did some other things that constitute crimes and he's paying the price. But as a client in the Nike case, I think he's not guilty. And I find it terribly disturbing that conviction still stands. But to the judge's credit, the sentence he imposed on Michael did not accrue any additional time for him because it was concurrent to the other sentences that Michael is serving. So at the end of the day, Michael, as I understand it, isn't serving one more day for that Nike case, although he's got a felony conviction that hopefully one day, maybe pursuant to a writ of error coram nobis, will be vacated.
Scott, you mentioned stress before. To me, the worst part of a case is when the jury walks out to go deliberate, especially out of town, because there's nowhere to go. You're just sort of stuck in limbo walking around. What do you and Howard do when the jury goes out, and how long was the jury out in the case?
I don't recall how long they were out, actually. Howard, do you remember?
No, but we did go get Chinese food, David, near that apartment where you stayed.
Yeah, we got Chinese food. We got in a location that, like, the week after was infested with COVID, probably when we were having lunch as well. But listen, we thought we had a shot during deliberations when the jury came out with that note. And once the judge responded to the note the way he did, it deflated us, because we knew what the jury was asking. And they were asking whether they could infer that Avenatti was acting within the scope of his representation. And
how did the judge respond to it? What did the judge say?
You basically said you cannot draw inferences. They're only relevant for Avenatti's state of mind, and not for whether or not, Franklin actually authorized these activities within the scope of the representation. It was a very confusing response. I still am confused by it, but he certainly didn't answer it the way we thought it should have been answered.
Here was the answer. The judge said that the jury, quote, could draw inferences from exhibits that were admitted to demonstrate state of mind, but only as to state of mind.
Yeah.
The exhibits received without any limitation may be considered by you for all purposes, including for their truth. But where I admitted an exhibit for purposes of demonstrating state of mind, that exhibit can only be considered for purposes of state of mind and not for the truth of the statements that were made in that exhibit. Now, 12 people who didn't go to law school, do they have any idea what the judge just said?
12 people who went to law school wouldn't know what the judge just said.
The point we were trying to raise, David, was that from the text messages that Franklin was exchanging with Auerbach, the ones that were admitted in evidence, that they could infer that they actually communicated their wishes to Avenatti. That after texting for a year about wanting justice and wanting to bring Nike to its knees and wanting to hold Nike accountable, that it was unreasonable to expect that when Franklin and Auerbach were in the room with Avenatti, their lawyer, who was going to achieve their objectives, that they would not communicate those wishes to Avenatti. And we asked the judge to instruct the jury that the jury may infer whatever they want to infer from those text messages, including that they communicated the wishes to Avenatti. And so there you have it.
In other words, the way the judge left it with the jury is that unless we could prove through direct evidence that Avenatti was told by Auerbach and Franklin what their objectives were, the jury could not infer from their own text messages between Auerbach and Franklin that, in fact, they had communicated their wishes.
That's a reasonable inference that if they text about it, they would have told their lawyer about it.
But they denied it on the witness stand, and they were obviously lying about it, but we weren't allowed to contradict them with their own words.
Just crazy. And in a lot of ways, these prosecutions against lawyers are always sort of, stretching what the criminal line is against lawyers. We've seen it from your cases back in the 90s to the Ben Cuny prosecution here in Miami, when Judge Cook rightfully said they crossed the line with the prosecution, to a case that Scott and I did recently with a lawyer, a similar extortion type case that the state dropped on the eve of trial. So thanking you guys for, one, fighting for lawyers, so important, and two, of course, appearing on the best podcast that we have today. So I want to just thank you both for doing it. It's been so great to have you both, two of my law heroes down here in Miami.
David, it's been a pleasure. I just have one last question. I've used your podcast to get CLE credit. Do I get CLE credit for being on the podcast?
We can deal with that. I'll try to arrange it and try not to get charged with a crime for getting you CLE credit.
Appreciate it.
Thanks, guys.
Well, that's a wrap on season 6.
Thank you to the Srebnick brothers for appearing and for telling us such a great story about the Michael Avenatti trial. I want to thank all the guests that appeared this season. We've had quite an interesting list of guests, from Trump's lawyers to Clinton's lawyers to the former Attorney General Alberto Gonzales to Caitlin Collins. It's been a really, really fun season with fun guests. Also, for those Florida lawyers listening, there's a CLE code for the whole season. That CLE code is 240-8860N. Again, 240-8860N. Thanks again for listening. If you enjoyed the show, please comment and like it and send it to your friends. That's the only way we can get out there. We'll be back with season 7 probably in about 6 months. But for now, thank you for listening. I had the best time doing this show, meeting all the people who have reached out because of the show and interacting with some wonderful guests. Thank you again for listening For the Defense. My name is David Markus. Thank you.